A very warm welcome to Learn Life. I'm Shashank Mishra as a host, present with renowned senior advocate of Supreme Court of India, Subodh Markandeji. This initiative to discuss legal topic, current affairs, and current issues which are going in India. Today we will deal with the famous Khajoor Singh case. First, I will tell the brief of the case, after which sir will deal in detail. A seven judges bench of the Supreme Court held in Khajoor Singh case that only Punjab High Court and not any other High Court in the country had the power to issue writs to the Union India. Devastating effect to this case was felt across the nation. In this episode, we will tell you why this happened and how it's affected. Kindly tell us what is Khajoor Singh's case and what was the declaration of law, sir.
Uh, Lieutenant Colonel Khajoor Singh versus State of Jammu and Kashmir is the decision of a bench of seven honorable judges reported in AIR 1961 SC 532. So the factual background was like this. The central government, by a letter sent from New Delhi, prematurely retired uh, Lieutenant Colonel Khajoor Singh. So he filed a writ petition in the Jammu and Kashmir High Court under Clause 2, Capital A of Article 32, that is corresponding to Article 226 of the Constitution, for quashing the said letter, prematurely retiring him from service. The central government raised a preliminary objection that the Jammu and Kashmir High Court has no jurisdiction to entertain the writ petition. That was supported by two earlier decisions of the Supreme Court in Election Commission versus Saka Venkatra Subbarao, 1953 SCR 1144, and K.S. Rashid and Sons versus Income Tax Investigation Commission, 1954 SCR 738. So the High Court upheld the preliminary objection of the central government and dismissed the writ petition of Lieutenant Colonel Khajoor Singh. So he appealed to the Supreme Court. Now, for an authoritative pronouncement on this important issue, having far-reaching consequences, the Supreme Court constituted a bench of seven judges. Uh, Three separate judgments were delivered by seven judges. The first one by the Chief Justice of India, uh, B.P. Sinha, who also spoke for Justices J.L. Kapoor, P.B. Gajendra Gadkar, K.N. Vanchu, and J.C. Shah, and uh, Justice K.C. Dasagupta wrote a separate judgment concurring with the majority. Uh, Justice Koka Subbarao gave a powerful dissenting judgment. So now let us see all the three judgments. In their judgment delivered by the Chief Justice of India, five judges concurred with the High Court that the point in issue regarding the lack of jurisdiction of Jammu and Kashmir High Court is covered by its earlier judgments in Saka Venkat Subbarao's case and K.S. Rashid and Sons case. So they proposed that appeal be dismissed. They concluded, in any, and I quote, if any inconvenience is felt on account of this interpretation, the remedy is through a constitutional amendment. The second judgment was by Justice Subbarao. That's a very erudite judgment. And he noted that acceptance of this view will practically deprive the majority of citizens of India of the cheap and expeditious and effective remedy under Article 226 of the Constitution. He reasoned that if the relevant provisions are clear and unambiguous, then of course the contention must prevail. But if the words of Article 226 are capable of two or more interpretations, then that interpretation should be accepted, which will carry out the intention of the Constituent Assembly. And So that's the interpretation which should be accepted, and the other one should, if there is another interpretation which would defeat the uh, intention of the founding fathers, then that must be rejected. So he further said that Constitution being an organic document, its provision must be construed broadly without doing any violence to the language. That is in a in a common sense view, and you know what in common parlance today is called purposive purposive interpretation. He further reasoned that constitutionally or legally, Union of India has no fixed situs. It is present everywhere in India through its officers. On the contrary, the situs of the Election Commission and the Income Tax Investigation Commission was provided by law, and hence those two cases of Saka Venkat Subbarao and K.S. Rashid are distinguishable. He further held that the High Court, within whose jurisdiction the cause of action arose, wholly or in part, ought to have the jurisdiction to entertain the writ petition. So viewed, the Jammu and Kashmir High Court had the jurisdiction to entertain the writ petition of Lieutenant Colonel Khajoor Singh. For the reason, for these reasons, he would allow the appeal, and consequently also the writ petition filed by uh, Khajoor Singh, and quashed the letter of premature retirement passed by the central government. Justice Dasagupta held that he agreed with Justice Koka Subbarao that Union of India is there within the jurisdiction of every high court in India. But he reasoned that only that high court has the jurisdiction to issue writ under Article 226, within whose territorial jurisdiction the act or omission against which the relief is sought took place. Since in Khajoor Singh's case, the act against which the relief sought was performed was at New Delhi, the Jammu and Kashmir High Court had no jurisdiction. He therefore agreed with the Chief Justice of India and the four other honorable judges to dismiss the appeal, but of course for different reasons. So, in accordance with the opinion of the majority, the appeal was dismissed. And
So what happened next then?
so this judgment created a lot of furore throughout India. The legal circles everywhere in every state, because every high court lost jurisdiction except the Punjab High Court. Every other high court had no jurisdiction whenever a relief is sought against Union of India. This was a very untenable situation. Uh, Actually, the Punjab High Court became some kind of super high court, which alone had the power to issue writ against the Union of India, and no other high court in India had that power. So, all the bar councils, all the legal circles, informed legal circles, they were very much concerned. And two separate bills were tabled within matter of months in the Lok Sabha to amend Article 226, as suggested by the majority, to nullify the effect of law laid down in Khajoor Singh's case. So one bill was by Mr. C.R. Pattabhiraman, and the other was by another member of Lok Sabha called Mr. Narsimhan. But you see, in deference to the views of overwhelming majority of informed legal circles of the country, the law minister assured that he would himself bring a constitutional amendment act. But that took a lot of time. See, the judgment in Khajoor Singh's case came in December 1960, and uh, the Constitution 15th Amendment Act was introduced in 1963. 3 years had passed in the meanwhile. So Uh, this 15th Amendment, by its section 8, inserted clause 1 capital A in Article 226, thereby empowering all the other high courts in India to issue writs to the central government on the basis of, so basis of, on what basis you can issue the writ? On the basis of accrual of cause of action within their territorial jurisdiction. So this is what was held by Justice Koka Subbarao. So ultimately, the powerful dissent of Justice Subbarao prevailed, and of course, 3 years passed by. I have a personal note here because at that time I was a student of LLM and I was writing a dissertation, the subject of which was constitutional remedies and their scope in India. So I was very much concerned because it directly related to my own dissertation. So I requested the Secretariat of Lok Sabha to give me copies of those two bills tabled by Mr. Pattabhiraman and Mr. Narasimhan. Uh, and they were good enough to send me those bills. I incorporated them in my dissertation. But as I said earlier, the law minister himself had assured on the floor of the house that he would bring, a constitutional amendment. That took a lot of time because 15th Amendment is not just relating to amendment of Article 226, but so many other articles. Its Section 8 deals with this Article 226. So, but I think if a purposive interpretation was given, as suggested by uh, Justice Subbarao, all this trouble would have been obviated. So we can understand the take of this whole is that purposive interpretation is very essential.
Yes, sir.
Other 6-1, and they had to bring out, the in, the amendment to the constitution.
It's for all the good, sir, that the case was dismissed. And hope we will see you in the next video. Thank you, sir, for joining.
Thank you.